is the transcript of the March 13th hearing between the Dissidents and Ionic Digital before Vice Chancellor Bonnie David of the Chancery Court of Delaware. The court opened. Could counsel please enter their appearances, beginning with the plaintiffs? Attorney Bayless responded, "Good afternoon, Your Honor. Tom Bayless for the plaintiff. It's my pleasure to introduce Adrian Ward, Jacqueline Ma, and Daniel Stone, all of Olshan from Wolski. Dan McBride and Nick Maestra from my office are also on the line." Attorney Lessner, this is Marty Lessner, Young Conway on behalf of defendants. On the phone with me, I have Alberto Chavez and Andrew Sirkowski. The court responded, "Thank you very much. I very much appreciate everyone making the time to get back on the line this afternoon. I asked for this teleconference so that I could deliver my post-trial ruling in this matter. I think that doing so by oral ruling is the fastest way I can get the parties an answer here, so that's why I've decided to do it this way. I will apologize to the parties in advance for the length of this ruling. If we had more time, it most certainly would be shorter, but I appreciate the parties' patience as I get the ruling on the record. I'll just ask everyone to please mute your lines until the ruling has concluded. This is my post-trial ruling in this action, through which plaintiffs Vitan or Tony Vaselli, Brett Perry, and Christopher Villinger seek an order compelling the production of the stock list of defendant Ionic Digital Inc., which I'll refer to as Ionic, or the company, pursuant to sections 219 and 220 of the Delaware General Corporation Law. For the reasons I'm about to explain, the court will enter judgment for the plaintiffs and order the production of the stock list materials. The following background facts are true as I find them after a one-day trial held on March 11, 2025. In reaching these findings, I have not considered documents that were belatedly produced, nor have I considered deposition testimony other than as permitted under Court of Chancery Rule 32. The plaintiffs here are stockholders of Ionic, a Delaware corporation that was formed in January of 2024 as part of Celsius Network LLC's Chapter 11 proceeding before the U.S. Bankruptcy Court for the Southern District of New York. Celsius, a cryptocurrency lending platform, filed for Chapter 11 bankruptcy in July of 2023. Celsius's founder, Alex Mashinsky, was later indicted and pled guilty to securities fraud and commodities fraud. Ionic was incorporated on January 5th of 2024 to hold certain Bitcoin mining assets. In the bankruptcy proceeding, Ionic was sponsored by US Bitcoin, now known as Hut 8, which received a separate class of Ionic stock, entitling Hut 8 to 2 seats on Ionic's board of directors. Hut 8 was also to provide services to Ionic, including constructing, running, and maintaining Ionic's core Bitcoin mining operations under a management services agreement. Ionic has a classified board of directors consisting of 3 classes. Initially, Ionic's board comprised 8 directors, including 3 in Class 1, 3 in Class 2, and 2 in Class 3. 2 directors were appointed by Hut 8, and 6 were appointed by a committee of unsecured creditors in the bankruptcy proceeding. In addition, under the court-approved bankruptcy plan, Plaintiff Perry and 2 other creditors were appointed as board observers. Again, because Ionic was the product of the Celsius Chapter 11 bankruptcy proceeding, all of Ionic's stockholders, including the plaintiffs here, are former creditors of Celsius. The plaintiffs here lost anywhere between hundreds of thousands to tens of millions of dollars as a result of the fraud that occurred at Celsius. Vaselli is now a record owner of 406 shares of Ionic common stock. Perry is a record owner of 45,960 shares of Ionic common stock, and Villinger is a record owner of 117,142 shares of Ionic common stock. Plaintiffs met during the Celsius bankruptcy process through service on creditors' committees and remained in touch with one another and other creditors through social media, emails, and text messages. Now, approximately 14 months since Ionic's formation, plaintiffs share a number of concerns about Ionic's business and its board of directors. Chief among those concerns, each of the plaintiffs has emphasized that a crucial goal in forming Ionic was to provide creditors with liquidity. To that end, on January 26 of 2024, Ionic filed with the SEC a Form 10 for registration of securities in contemplation of an initial public offering and NASDAQ listing. But despite that filing, Ionic stock still does not trade on any exchange. In addition, since its formation in January of 2024, Ionic has undergone significant board and management changes. Ionic has had 3 CEOs, 3 CFOs, and 2 chief legal officers. In May, Ionic's auditor resigned, and the company did not engage a new auditor until October of 2024. And only 3 of the 8 directors who were appointed in January of 2024 to serve on Ionic's board remain. Plaintiffs also contend that Ionic's board members have awarded themselves excessive compensation, including, for each director, $240,000 in annual compensation, $5,000 to $40,000 for service on standing committees, and an additional $180,000 to $195,000 for service on an emergence committee. These developments have left plaintiffs and other Ionic stockholders disappointed with the company's progress over the past year plus and agitating for change. Non-party Figure Markets Inc., which is not an Ionic stockholder, is a blockchain-native, decentralized custody exchange for digital assets. Figure Markets runs an alternative trading platform, which the parties refer to as ATS. Non-party GXD Labs, LLC, is a digital asset and blockchain operating, investment, and advisory business. Like Figure Markets, GXD is not an Ionic stockholder. In late May of 2024, Figure Markets co-founder and CEO, Michael Cagney, contacted Ionic's board of directors, expressing a desire for Ionic to list its stock on Figure Markets ATS. Ionic's board did not accept that proposal. Also, in late May of 2024, GXD's co-founder and managing partner, David Proman, emailed Ionic's board, expressing a desire to replace Hut 8 as Ionic's management services provider. According to Ionic, GXD harbored resentment that Hut 8 had been chosen to provide operations management to Ionic coming out of Celsius's bankruptcy, calling it an abuse of the bankruptcy process. Proman's email suggested that Ionic's directors should speak up if you want to step down and find suitable replacements to do this work. The board did not accept GXD's proposal. Weeks later, in mid-June, GXD followed up, proposing a different fee arrangement, but the board did not accept that proposal. In the summer of 2024, Vasily began to contemplate the possibility of calling a special meeting of Ionic stockholders to effect change at the company. In late July, Vasily filed a letter on the docket in the Celsius bankruptcy proceeding, expressing concerns over Ionic's failure to publicly list its stock and what Vasily described as the shocking amount of turmoil among Ionic's directors and officers. Vasily's letter sought an update on operations, something that we have been promised over and over again, and suggested that the only other remedy would be to use the proxy rules afforded to shareholders. That letter is in the record at Joint Exhibit 12. Figure Markets had a similar idea. In August of 2024, Figure Markets attempted to purchase shares of Ionic stock with the intention of advancing a stockholder proposal to encourage Ionic's board to list the company's shares on Figure Markets ATS. Several Ionic stockholders expressed interest in selling their shares to Figure Markets, but according to Figure Markets, Ionic's board directed its transfer agent to refuse the transfers. In early August, Perry posted about Ionic on social media. On August 3rd, he posted, "Fellow Ionic shareholders, you've been kept in the dark too long. Let Judge Glenn, the judge in the Celsius bankruptcy proceeding, and the press know. I'll ensure your voices are heard by the board and management. Reject the misuse of our money as a personal piggy bank and lack of respect shown to us all. That is in the record at Joint Exhibit 14. The same day, Perry reached out to Figure Markets CEO Michael Cagney, seeking guidance on how to influence a pivot with the current board of Ionic. Cagney responded by sharing Figure Markets' proposal to list Ionic stock on Figure Markets ATS, and suggested that seeking change could be as simple as asking for a shareholder vote. Perry responded, "My real concerns are about the lack of communication with shareholders and the withholding of information and discussions from board observers. The company has a similar vibe to when it was in bankruptcy, which seems to involve the same people profiting at the expense of shareholders." Cagney suggested a shareholder referendum on replacing the board and offered to help or act as a sounding board. That is in the record at Joint Exhibit 17. Perry subsequently received a letter from Ionic asserting that Perry had breached his board observer agreement with Ionic due to his recent social media activity and was being removed as a board observer. On August 8th, Ionic disseminated an update to its stockholders, which is in the record at Joint Exhibit 13. The update discussed developments with the facility in Cedarville, Texas, and also disclosed a significant leadership transition, namely that in July of 2024, the company's CEO had informed the board of his decision not to extend his employment agreement beyond its initial term, and that the board had initiated a search for a new CEO. The update also identified several changes to the board and disclosed that Ionic's auditor had resigned due to a strategic decision by the auditor to disengage from all audit engagements with companies in the cryptocurrency sector. Like Perry in the summer of 2024, Viselli took to social media to express frustration with Ionic. Viselli's posting garnered the attention of other Ionic stockholders, as well as Figure Markets. On August 9th, Figure Markets' chief investment officer, Michael Abate, contacted Viselli, explaining that, "I saw you mention the 25% shareholder threshold in one of your tweets to call a special board meeting. Do you know where you saw that?" Viselli responded, "That's usually the standard procedure for any company." Abate told Viselli, "We should call a special meeting and put a listing on the ATS to a vote, as this is your fastest way to see some value in the mining business." That is in the record at Joint Exhibit 16. Figure Markets followed up with pitch materials it had prepared for Ionic's board, laying out Figure Markets' strategy for Ionic, which included appointing Abate as chairman of the board and listing Ionic Digital shares on Figure Markets ATS. The deck indicated that Figure Markets would effectuate its proposed plan either through a proxy vote or a special meeting of the current board. Viselli also spoke with Cagney to discuss the mechanics of potentially calling a stockholder meeting, which Viselli said he learned from kind of just Googling everything as he went. At the same time, Viselli contacted a group of Ionic stockholders, including plaintiff Villinger, by text message, sharing a screenshot of a message from Cagney confirming that the support of 25% of Ionic stockholders was needed to call a special meeting. Viselli encouraged those stockholders to join the effort to call a special meeting by sending their share counts to add to a letter explaining we need to get to 9.25 million shares, which is 25%. Viselli later reported to the same group that he had a good call with Cagney. He's going to put in an offer. They want to convene the vote, and Abate said he has the claim buyers on board. Did we just start a coup? LOL. That is in the record at Joint Exhibit 15. Meanwhile, Cagney contacted Ionic, expressing interest in a proposal that would involve board change and listing Ionic stock on the ATS. Cagney explained that otherwise we have to agitate for a special board meeting with 25% of shareholders asking for it. We do have the big claims buyers and might be able to pull this off, but I'd rather work with the board on this. A few days later, on August 12th, Cagney followed up with a formal proposal that anticipated appointing Abate as chairman of the board, replacing HUD 8, and listing Ionic on Figure Markets ATS, among other things. The same day, Figure Markets also published a statement directed to Ionic stockholders, asking for shareholder support to force a board meeting to discuss the path forward for Ionic. The statement directed stockholders to an online forum to endorse holding a special meeting. While Ionic contends that the plaintiffs, including Viscelli, are simply figure markets proxies or surrogates, the trial record shows that throughout August and into the fall, Viscelli worked together with figure markets to further their mutual, or at least overlapping, goals, remaining involved at every step. For example, on August 13th, Viscelli filed another letter on the docket in the Celsius bankruptcy action, reporting that we are in the process of gathering a coalition of shareholders to remove the current manager and replace with a more qualified team of professionals. We have received a tremendous level of support from shareholders in only a few days of outreach, and we plan to ramp up our efforts if the board is unwilling to act. That is in the record at Joint Exhibit 33. When Viscelli posted a message on social media that apparently did not perfectly align with Figure Markets' goals, Abate said to Viscelli, "Hey bud, I just want to make sure we're on the same page. You're supporting us, not competing, correct?" And Viscelli replied that, "I'm not competing, but if it goes to a vote, I think it's best to remove them all and have a committee review best steps forward, which could be a sale, liquidation, or continuing operations. I don't know." That is in the record at Joint Exhibit 34. Viscelli sent Abate and Cagney some talking points on what shareholders are looking for to get Figure Markets on the same page with him. That is in the record at Joint Exhibit 38. Viscelli told other stockholders that he had officially/unofficially hired GDX to run the Ionic liquidation in a tag team with Cagney. That's in the record at Joint Exhibit 39. And Viscelli gave comments on a Figure Markets interview outline, which is in the record at Joint Exhibit 37. On the other hand, one communication in particular, at least facially and without further context, would seem to support Ionic's theory that Viscelli lent his name to the stock list demand at Figure Markets' request. On August 23rd, Abate emailed Viscelli that Figure Markets had engaged an absolute bulldog at Olshan as counsel. Abate explained that the next step is for Figure Markets to write a letter to Cleary, Ionic's counsel, asking for clarity as to why they are not allowing transfer of the shares. This is important because Figure Markets needs to be a shareholder to request a copy of the books and records from the registrar. Abate continued, "It is unlikely that we will get Cleary to respond quickly, so I am writing to you formally asking if we can use your shares to make the request to the company for the shareholder contact information. All that really means is that I need you to sign a short letter saying Olshan can send a letter to the company on your behalf." That is in the record at Joint Exhibit 44. Viscelli responded that they could request the books and records in his name. On August 30th, Figure Markets and Viscelli entered into the first of 4 group agreements governing their joint efforts concerning Ionic. The August 30th group agreement was for the purpose of working together to enhance stockholder value at Ionic, including by demanding the right to inspect, pursuant to Section 220 of Delaware General Corporate Law, a stockholder list and certain other books and records of the company for purposes of allowing the group to communicate with the company's other stockholders on matters relating to their interests as stockholders, and for purposes of taking all other action necessary to achieve the foregoing. In the August 30th group agreement, Viscelli agreed to give Figure Markets advanced written notice of, and an opportunity to pre-clear, any transactions involving Ionic securities, the right to pre-approve any SEC filing, press release, or stockholder communication, and the right to pre-approve in writing all reasonable expenses. But the group agreement did not require Viscelli to endorse Figure Markets' business proposals, and provided that Viscelli could terminate his obligations under this agreement on 24 hours written notice. On September 4th, Viscelli served a demand for inspection of books and records pursuant to Section 220 of the Delaware General Corporate Law, which I will refer to as the September demand, on Figure Markets' letterhead. The September demand sought to inspect 12 categories of documents, including Ionic stock list materials. The September demand authorized Olshan, Abate, and any of their respective partners, associates, employees, and other designees to conduct the inspection. Although all parties now seem to agree that it would not be appropriate for Figure Markets to have direct access to the stock list, I note that when the September demand was served, Viselli also sought other materials for the purpose of investigating potential wrongdoing that are not in dispute in this litigation. The same day, Figure Markets issued a press release announcing that, together with Vitan Viselli, a shareholder of Ionic Digital, Figure Markets had requested access to certain company records under Section 220 of the Delaware General Corporation Law. That is in the record at Joint Exhibit 62. In early September, Viselli continued to contact Ionic stockholders with a link to an online form endorsing a special meeting. The form stated that Figure Markets is reaching out to shareholders of Ionic Digital Inc. and its affiliates, allowing them to request a special meeting. It also stated, the shareholders with whom we are working intend to remove directors Thomas D. Fiore, Scott Duffy, and Emmanuel A. Dew from the board of directors of the company for cause. Take an advisory vote to grant immediate liquidity to shareholders of the Class A common stock. Take an advisory vote to appoint a qualified CEO. Take an advisory vote to terminate the management services agreement with Hut 8. That is in the record at Joint Exhibit 100. On September 12th, Ionic responded to the September demand, contesting Viselli's proper purpose for making it, but nevertheless agreeing to meet and confer on a potential production subject to a confidentiality agreement. Thereafter, the parties negotiated over a confidentiality agreement governing how the stock list materials would be used. On September 27th, Proman of GXD asked Viselli whether Perry would be willing to cooperate with Figure Markets and GXD. Viselli responded that Perry was more than willing to meet up and help us in any way possible, having offered multiple times already. That is in the record at Joint Exhibit 78. On October 7th, Figure Markets and Viselli entered into an amended and restated group agreement that added another third party, Nexus Holdings Advisor LLC, as a member of the group. 2 weeks later, on October 21st, Figure Markets, GXD, and Viselli entered into a new group agreement, disbanding the prior group with Nexus, with GXD stepping into its place. On October 28th, Figure Markets, GXD, Olshan, and Viselli met with the board, encouraging it to replace certain directors, appoint a new CEO, and immediately list Ionic stock. The group also proposed that Ionic terminate its contractual relationship with Hut 8 and appoint GXD as Ionic's asset recovery manager. On October 31st, Ionic proposed a draft confidentiality agreement to govern production of the stock list. The proposed draft prohibited anyone other than Viselli from directly or indirectly paying, reimbursing, or otherwise covering any costs incurred by the stockholder in connection with the company, the demand, or this agreement. The parties referred to that proposed language as the outside funds provision. Viselli did not agree to the outside funds provision. On November 5th, Viselli reached out to Villinger and other stockholders, explaining that Ionic was giving him the runaround about getting the shareholder list, and asked if they would join the 220 filing with him for books and records, stating that it would be just the same thing I sent out, but with your names and number of shares on it. Viselli explained that Ionic had refused to turn over the stock list because he was alleged to be a small shareholder and acting as a puppet to Figure and GXD, but suggested that, if there's more of these demands, Ionic can't say it's all these puppets, lol. That's in the record at Joint Exhibit 170. Perry supported Viselli and emailed his network on November 6th, explaining, "We need additional shareholders to join Tony Viselli's petition to the court to compel Ionic Digital's cooperation, and that your support as a major shareholder would make a significant impact, and all attorneys' fees for this effort are already covered." By November 30th, 9 Ionic stockholders, including Villinger and Perry, entered into a representation letter with Olshan in connection with a demand for books and records to Ionic, under which Figure Markets and GXD would be responsible for legal fees. On December 11th, Perry, Villinger, and 7 other stockholders sent Ionic a Section 220 demand seeking a copy of the stock list and related materials. I will refer to that demand as the December demand. The stated purpose of the December demand is to enable the stockholders and certain of their affiliates and representatives to communicate with the company's other stockholders on matters relating to their mutual interests as stockholders of the company, including but not limited to, in connection with the stockholder meeting, the election of directors at the stockholder meeting, and any other matters as may properly come before the stockholder meeting. That is in the record at Joint Exhibit 218. On December 17th, the 9 stockholders, through counsel, sent Ionic's counsel a form of confidentiality agreement that omitted the outside funds provision. Ionic again refused to produce the stockholder list and related materials without the outside funds provision. In late January of 2025, plaintiffs formally engaged Olshan and Delaware counsel to represent them, with Figure Markets and GXD agreeing to pay the cost of the litigation. The Olshan engagement letter provided Figure Markets and GXD the right to approve a complaint before filing and to consult on strategy. On February 6th, Ionic issued a press release announcing that it would hold its annual meeting on March 17th of 2025. On February 14th, plaintiffs delivered a nomination notice to Ionic, nominating Abate and Oliver Weiner to serve as Class 1 directors. The same day, Figure Markets, GXD, and Viselli terminated the October 21 group agreement, and Perry, Viselli, Villinger, Figure Markets, and GXD entered into a new group agreement for the purpose of supporting the nominating stockholders in their efforts to achieve the election of the persons they have nominated, at the nominating stockholders' sole discretion, to the board of directors of the company at the 2025 annual meeting of stockholders of the company. That is in the record at Joint Exhibit 264. Under this agreement, plaintiffs have the sole power to decide who to nominate for election to the board and may change their current choice to nominate the nominees in their sole discretion. The parties also agreed that decisions of the parties concerning strategy and the actions to be undertaken in pursuit of the purpose, including, without limitation, any changes to the purpose other than the selection of the nominees for election to the board, which shall be in the sole decision of nominating stockholders, shall be made by unanimous written consent of the parties. No party shall undertake any significant action in pursuit of the purpose or materially alter strategy previously agreed upon by the parties without first consulting with and obtaining written consent on the new action or change in strategy from each of the other parties. As for termination, the parties agreed that any party hereto may terminate his or its obligations under this agreement, other than those set forth in Section 5 for paying expenses and Section 10 governing law, on 24 hours written notice to all other parties. On February 10th, plaintiffs initiated this action, seeking an order compelling the inspection of Ionic stock list materials under Sections 219 and 220 of the Delaware General Corporation Law. At a hearing on February 12th, the court expedited this matter to resolve it in advance of Ionic's upcoming annual meeting. Plaintiffs filed an amended complaint on February 21st, which Ionic answered on March 2nd. On February 25th, plaintiffs filed a motion to compel, which the court granted in part on February 28th. On March 4th, defendant filed a motion to compel document production from subpoena parties, Figure Markets, and GXD, or, in the alternative, to vacate trial date, or, in the alternative, for adverse inferences against plaintiffs. On March 5th, the court granted the motion to compel, denied the request to vacate the trial date, and reserved decision on the parties' requests for adverse inferences and fee shifting until after the trial. The court held a one-day trial on March 11th of 2025. With those factual findings, I turn to the legal analysis. Before reaching the merits, I first consider Ionic's argument that purported discovery abuses committed by third parties support an adverse inference that plaintiffs seek Ionic stock list for an improper purpose. An adverse inference is an extreme measure, but may be warranted in the unusual circumstance where a litigant intentionally suppresses or destroys pertinent evidence. The Delaware Supreme Court has instructed that an adverse inference is appropriate where a litigant intentionally or recklessly destroys evidence when it knows that the item in question is relevant to a legal dispute or it was otherwise under a legal duty to preserve the item. That is from Sears, Roebuck & Company v. Midcap. It is not enough that the absence of evidence is not adequately explained. Likewise, the negligent destruction of evidence does not warrant drawing an adverse inference. Rather, the drawing of an adverse inference requires, as a predicate, a preliminary finding of an intentional or reckless destruction of evidence. Thus, drawing an adverse inference is appropriate when an actor is under a duty to preserve evidence and takes part in the destruction of evidence while being consciously aware of a risk that he or she will cause or allow evidence to be spoiled by action or inaction, and that a risk would be deemed substantial and unjustifiable by a reasonable person. That comes from Beard Research, Inc. v. Cates. Ionic raises 4 arguments in support of its request for adverse inferences. First, Ionic says that, until Ionic moved to compel, Figure Markets and GXD refused to produce anything more than 6 documents and refused to sit for depositions. Second, Ionic asserts that even after the court granted Ionic's motion to compel, neither Figure Markets nor GXD appropriately collected text messages or adequately prepared their Rule 30b-6 witnesses to testify on the noticed topics. Third, Ionic argues at Figure Markets and GXD's depositions, both counsel for third parties and plaintiffs were coaching the witnesses through lengthy, improper objections, including incorrect business strategy immunity claims. And fourth, Ionic points to 2 versions of the same document, Joint Exhibit 400 and 401, in an effort to demonstrate that Figure Markets improperly applied redactions in discovery. In my view, none of these purported discovery abuses support the extreme remedy of drawing an adverse inference. For one, this is a highly expedited proceeding in which both plaintiffs and Ionic served extensive discovery, notwithstanding that summary proceedings of this nature tend to involve limited discovery and rarely involve discovery from third parties, given the narrow focus on the plaintiff's proper purpose. Admittedly, Figure Markets and GXD are not typical third parties, but they did ultimately review thousands and produce hundreds of documents, and prepared and made 30b-6 witnesses available to testify on an expedited timeline over a weekend for several hours each. GXD's counsel's conduct in the deposition excerpts that were played at trial was unsavory, even for a highly expedited proceeding over a weekend, and Ionic is not precluded from filing a motion for fees if it deems appropriate, providing an opportunity for GXD to respond. But on the whole, I do not find that Figure Markets and GXD's conduct supports the remedy requested. Nor do I believe inconsistent redactions made to one document in the context of highly expedited discovery supports an inference that Figure Markets and GXD intentionally or recklessly concealed evidence sufficient to justify an adverse inference against plaintiffs. So with that, I turn to the merits of plaintiffs' claim for Ionic stock list materials under Sections 219 and 220 of the Delaware General Corporation Law. Decisions of this court routinely describe a stockholder's right to inspect a corporation's stock list as virtually absolute. In Section 219A of the Delaware General Corporation Law requires a corporation to prepare no later than the 10th day before each meeting of stockholders a complete list of the stockholders entitled to vote at the meeting, which shall be open to the examination of any stockholder for any purpose germane to the meeting for a period of 10 days ending on the day before the meeting date. Section 219B provides that if the corporation or an officer or agent of the corporation refuses to permit examination of the list by a stockholder, such a stockholder may apply to the Court of Chancery for an order to compel the corporation to permit such an examination. The burden of proof shall be on the corporation to establish that the examination such stockholder seeks is for a purpose not germane to the meeting. In addition, Section 220C of the Delaware General Corporation Law states that where the stockholder seeks to inspect the corporation's stock ledger or list of stockholders and establishes that such stockholder is a stockholder and has complied with this section respecting the form and manner of making demand for inspection of such documents, the burden of proof shall be upon the corporation to establish that the inspection such stockholder seeks is for an improper purpose. In other words, under the statute, once a demand in proper form has been made, a proper purpose is presumed, and the burden of persuasion is shifted to the corporation to show an improper purpose. That comes from Hirschfeld v. Emory Air Freight Corporation. Once a proper purpose for a stock list is established, the existence of a secondary purpose is irrelevant. Ionic does not contest that plaintiffs are stockholders with standing to seek the stock list under the statutes, or that both the September demand and the December demand comply with the statutory form and manner requirements. Accordingly, Ionic bears the burden to prove that plaintiffs seek the stock list materials for an improper purpose. Plaintiffs contend that their purpose for seeking Ionic stock list materials is to facilitate their solicitation of proxies in advance of a contested election at the company's upcoming annual meeting, and to elect competent leadership who cares about the stockholders and their need to finalize their recovery from the Celsius bankruptcy. Facially, plaintiffs' stated purpose to run a proxy contest in advance of the annual meeting is a proper purpose for seeking a stock list. There can be no question but that the desire to solicit proxies for a slate of directors in opposition to management is a purpose reasonably related to the stockholder's interest as a stockholder. It has been held in this state that such a purpose is directly related to stockholder status and, as such, proper. That is from General Time Corp. v. Tally Industries, Inc. Ionic contends, however, that plaintiffs' stated purpose of running a proxy contest to improve corporate leadership is not their true purpose for seeking the stock list. A defendant facing a Section 220 action may resist that demand by showing that the plaintiff's purpose, although a valid one, is not the actual purpose. In other words, the defendant may try to show that the plaintiff has pursued his claim under false pretenses. That is from Sutherland v. Dardendale Timber Company. In rare circumstances, a defendant can prove that a stockholder lacks a proper purpose where the purpose for the inspection belonged to another person rather than the stockholder himself. That's from Simeone v. Walt Disney Company. Here, Ionic asserts that plaintiffs are merely proxies with an actual purpose of obtaining Ionic stockholder list for Figure Markets and GXD, and have adopted Figure Markets and GXD's improper purposes, which are to use the stockholder list for Figure Markets and GXD's own commercial purposes. According to Ionic, Figure Markets' commercial purpose is to have Ionic list its stock on Figure Markets ATS rather than on NASDAQ or another traditional stock exchange, while GXD's commercial purpose is to allow GXD to take over and manage Ionic's Bitcoin mining infrastructure and day-to-day activities, which could provide GXD with substantial benefits. Ionic argues that advancing the commercial interests of non-stockholders is not a proper purpose. And, indeed, even if Figure Markets and GXD's commercial purposes are not inimical to the corporation, if Ionic is right that the demands were made for reasons wholly unrelated to plaintiffs' role as stockholders, access to the ledger will be denied. Thus, the question before the court is whether Ionic has satisfied its burden to prove by a preponderance of the evidence that plaintiffs do not actually seek the stock list materials to run a proxy contest to elect competent leadership who will improve corporate governance at the company, but instead seek the materials to advance Figure Markets and GXD's commercial interests. After careful consideration of the parties' briefing, exhibits, and the evidence presented at or submitted in connection with trial, I find that Ionic has not met that evidentiary burden. I am convinced that each of the plaintiffs here seeks the stock list materials because he sincerely wants to run a proxy contest to improve governance at the company. Each of the plaintiffs has credible reasons for that purpose. The stockholders want greater transparency and liquidity for their shares, which have not traded for over a year, and numerous changes to Ionic's directors, officers, and auditor raise questions about the company's governance and strategic direction. As I just recited in detail, Viselli first proposed the idea of holding a special meeting of Ionic stockholders in June of 2024, before he teamed up with Figure Markets, and has actively participated with Figure Markets and GXD in seeking the support of other stockholders. Ionic suggests that Viselli does not truly seek to represent the interests of Ionic stockholders, and instead has lent his name to the demand in order to seek justice from individuals who angered him in the Celsius bankruptcy. But it is clear to me, both from Viselli's testimony and the larger record, that that is not the case. To the extent that there are hard feelings against current board members arising from the bankruptcy process, I find any such purpose is secondary at best, and is not Viselli's primary purpose for seeking this stock list. Ionic suggests that Viselli's relatively small economic stake in Ionic undermines his purpose. I tend to agree, and on the stand Viselli himself seemed to agree, that the significant amount of time and effort he has invested to coordinate Ionic stockholders may not be entirely economically rational, given the relatively small number of shares he owns. Yet, I remain convinced that Viselli seeks the stock list to run a proxy contest that he believes is in the best interest of Ionic stockholders, and not for any other purpose. Moreover, even if there were reasons to doubt the sincerity of Viselli's purposes, both Villinger and Perry have significantly larger shareholdings in Ionic. Villinger was Celsius's seventh largest creditor and lost in the 8 figures in the bankruptcy, while Perry lost approximately $30 million. Both testified credibly that they are focused on finding qualified, competent managers and a path to liquidity. Accordingly, I find plaintiffs' stated purposes for seeking the stock list are sincere. I further find the plaintiffs are not simply proxies, surrogates, or shills for Figure Markets and GXD. Importantly, nothing in the trial record suggests that any of the plaintiffs have received or expect to receive any personal benefit from Figure Markets or GXD, such that they would have any incentive to support the commercial interests of those non-stockholders if they did not align with plaintiffs' interest as stockholders. That alone distinguishes this case from the principal authority on which Ionic relies, Carpenter v. Texas Air Corp., a case in which the court found that a plaintiff sought a stock list to advance his separate interest as a union member instead of his interest as a stockholder. Of course, the record makes clear that Figure Markets and GXD do seek the stock list materials to advance their own commercial interests, and the plaintiffs don't sincerely contest that. But in my view, plaintiffs seek to advance Figure Markets and GXD's purposes only to the extent that they are aligned with plaintiffs' own purposes for improving governance and access to liquidity. And, under Delaware law, plaintiffs may align themselves with non-stockholders so long as their own purposes are proper, as Hirschfield v. Emory Air Freight Corp. And Trans World Airlines Inc. v. Portery for Story both make clear. In reaching this conclusion, I do acknowledge one communication in the record that, without the full context of the parties' discussions, supports Ionic's theory that Viselli simply lent his name to the demand. In particular, as I noted earlier in this ruling, Figure Markets asked Viselli if it could use his shares to serve the demand, and Viselli responded that Figure Markets could request the books and records in his name. Despite that shorthand, the full record makes clear that Viselli has worked closely with Figure Markets and GXD to further their shared goal of mobilizing Ionic stockholders, remaining involved at every step. Defendants also point out that under the parties' various group agreements, Figure Markets and GXD have the right to approve or pre-clear transactions involving plaintiff stock, public communications, and expenses. Figure Markets and GXD also had the right to approve the complaint before filing and to consult on strategy. But on the other hand, as Viselli explained repeatedly at trial, those agreements could be terminated with 24 hours notice to the extent plaintiffs ever determined that their interests no longer aligned with Figure Markets and GXD, and the parties' latest agreement also gives plaintiffs the sole power to decide whom to nominate for election to the board. So on balance, for all the reasons I've just explained, I find that the plaintiffs are not proxies or surrogates for Figure Markets and GXD. Finally, Ionic claims that plaintiffs' purpose of running a proxy contest is improper because, financially, plaintiffs have admitted that they could not accomplish that on their own. I find that argument wholly unconvincing. It is clear from the record that, with Figure Markets and GXD's financial backing, plaintiffs can and will run a proxy contest. And for all the reasons I just explained, despite Figure Markets and GXD's separate commercial purposes and financial support, I find that the plaintiffs' stated purposes are sincere, their own, and therefore proper. To summarize, Ionic has not satisfied its burden to prove that plaintiffs seek the stock list materials for an improper purpose. Ionic, therefore, must produce to plaintiffs the same lists and data relating to stockholders as is available to the corporation. That comes from Hatley Corp. v. Lane Bryant, Inc. Ionic also argues that, in the event the court finds that the plaintiffs have a proper purpose and are entitled to Ionic's stockholder list, it should be conditioned on a confidentiality agreement that provides the list only to a proxy solicitation firm that is independent from and not directed or paid for by Figure Markets or GXD or any of their representatives or agents. Section 219B provides that the court may permit examination of the list upon such conditions as the court may deem appropriate. And Section 220C similarly states that the court may, in its discretion, presume any limitations or conditions with reference to the inspection. At trial, all parties recognize that there are unique sensitivities arising from the bankruptcy proceeding that warrant treating the stock list with particular care, and plaintiffs themselves acknowledged that only a proxy solicitor should have access to the stock list materials. Accordingly, Ionic must produce the stock list materials to counsel for delivery to the proxy solicitor, and no plaintiff should directly access those materials. Given that the plaintiffs have demonstrated a proper purpose for the stock list, I see no basis to impose the onerous outside funds provision that Ionic seeks. But to be clear, the plaintiffs have the proper purpose for seeking the stock list. Figure Markets and GXD do not. Figure Markets and GXD are not prohibited from funding the plaintiffs' efforts, but the stock list may not be accessed by either Figure Markets or GXD, and Figure Markets and GXD may not direct the proxy solicitor. So in other words, the proxy solicitor must take direction from the plaintiffs and their counsel only, notwithstanding the terms of any group agreement. I will leave it to the parties to work out the language of an appropriate confidentiality order consistent with that guidance, but that process may not delay Ionic producing the list to plaintiffs' counsel today. Finally, plaintiffs argue that Ionic's aggressive and abusive pre-litigation conduct and litigation tactics merit fee shifting. Delaware courts allow the American rule that each party is generally expected to pay its own attorney's fees regardless of the outcome of the litigation. Even under the American rule, however, this court retains the ability to shift fees for bad faith conduct to deter abusive litigation and protect the integrity of the judicial process. In assessing bad faith, this court can consider both litigation-related conduct and the parties' pre-litigation conduct. Although there is no single, comprehensive definition of that bad faith that will justify a fee-shifting award, this court commonly employs the glaring egregiousness standard. The plaintiffs assert that Ionic's pre-litigation conduct, conditioning production of the stock list materials on an unjustified and unprecedented outside funds provision, obstructed plaintiffs' statutory rights and their right to nominate and run their alternative candidates. Plaintiffs also assert that during this summary proceeding, Ionic engaged in over-the-top litigation tactics, including filing a motion to dismiss, which is disfavored in a summary proceeding, and serving written discovery that this court described as facially overbroad. In my view, the parties' conduct during this expedited summary proceeding does not come close to meeting what I view as an extraordinarily high bar to justify fee shifting. The defense raised in response to the demands, while it did not win the day, was far from frivolous, nor was the parties' conduct glaringly egregious. So for that reason, the request for fee shifting is denied. That concludes my oral ruling. Ionic must produce the stock list materials without further delay, subject to the conditions that I just described. The parties are directed to file a proposed form of order to implement this ruling. I know that was a lot to digest, but is there anything else that we can accomplish on the call this afternoon? Was that ruling clear? Mr. Bayless? Attorney Bayless says, Your Honor, thank you very much. It was clear. We appreciate the court's time and attention. I just have one question, which Your Honor may direct me to raise with Mr. Lesner first, but it's a practical one, and that is that the plaintiff effectively has to direct the proxy solicitor, and what I'm concerned about is an NDA that would effectively prevent communication between the plaintiff and the proxy solicitor on the grounds that because the plaintiffs aren't entitled to see the stock list materials, they can't effectively communicate with one another. My sense is that wasn't Your Honor's intent behind the ruling, but I wanted to make sure because I'm anticipating that we might have a fight under the NDA. The court responded, That's not my intention. My intention is to make clear that the plaintiffs have a proper purpose, but Figure Markets and GXD do not have a proper purpose. So it should be the plaintiffs who are directing the proxy solicitor and not Figure Markets and GXD. How the parties work that out in terms of a stipulation, I will rely on you all to figure out the right language to implement that. But that is my intention. Does that address your concern? Attorney Bayless responds, I think it does, Your Honor. Thank you very much. Attorney Lesner says, Your Honor, this is Marty Lesner. Just so we're clear, we are clear on the court's order. We are prepared to send to Mr. Bayless a link and a password to an FTP file, which we understand Mr. Bayless and his firm only would be sending to the proxy solicitor. The subtle issue here is that Olshan represents Figure Markets, and they also represent GXD. And so we're not going to send it over to Mr. Bayless's co-counsel, just to Mr. Bayless, for purposes of sending it to the proxy solicitor. It's also an FTP file that we can see who's accessing it. So we understand that the only people who will be accessing that file will be the proxy solicitor. Whatever communications, we heard, Your Honor, whatever communications the plaintiffs have with them, they won't be getting the list. They'll have whatever communications they have regarding the proxy solicitor, but we also understand that Figure Markets and GXD should not have any communications with the proxy solicitor. That's our understanding, and with that, we're prepared to send Mr. Bayless, at the conclusion of this hearing, we'll send him the FTP file and the password to pass on to the proxy solicitor. The court responded, Mr. Bayless, do you want to respond to that? Is there any reason why I shouldn't limit access to that FTP site to you and your firm? Attorney Bayless responds, Your Honor, here's what I suggest. I suggest that Mr. Lesner send the FTP to my firm. We'll get it to the proxy solicitor. I do think that as a part of wrapping this piece up, we should reach an agreement on a proposed form of NDA that's going to cover us going forward. If we can't reach agreement, we would just submit competing forms of NDA, and Your Honor can just pick one. I'm just anticipating that there is going to be a fight because we've asked for a form of NDA that was attached as Exhibit C to our amended complaint. We believe that's the right one. We might make a modification or two to reflect Your Honor's ruling, but I'm just concerned we're going to end up in a fight. I'll try to work it out with Mr. Lesner in the first place, and if we can't, we'll come back to the court. In the meantime, the pressure should at least be off to some extent because our proxy solicitor will have the materials, if no one else. The court responded, I think that's a reasonable suggestion, so I'm limiting access to that FTP site to you, Mr. Bayless, and your firm. The parties should meet and confer on the proposed form of confidentiality order and come back to me if you need some resolution. Attorney Lester responded, Your Honor, this is Marty Lesner. If I could clarify, I believe what Mr. Bayless said, he can correct me, is that access to the FTP site should only be the proxy solicitor and will negotiate with Mr. Bayless regarding the terms of the NDA. Mr. Bayless's firm, who represents and is paid for by Figure Markets and GXD, should not have access to the stock list. That's the same as the plaintiffs having it. What I think we agree on is that we're going to send Mr. Bayless the link. He's going to send that list to the proxy solicitor. The proxy solicitor will be able to have access to it, but not Mr. Bayless's law firm. I think that's what we're in agreement on. In the meantime, that's the order that's going out. That's what we're going to do today, and then Mr. Bayless, and I will sort of paper that over with the appropriate NDA. The court responded, Mr. Bayless, are you in agreement with that? Attorney Bayless responds, Your Honor, I'm willing to proceed on that basis for now, but I think that's an unreasonable request, including because it effectively makes communications between the plaintiffs and their lawyer effectively impossible, and it potentially makes communication between the plaintiffs and the proxy solicitor effectively impossible. So we're going to likely have a fight over the form of NDA, but at least for the immediate term, I'm willing to take the FTP and shoot it to the proxy solicitor so that we can get started on that front, and we'll fight like heck over the NDA in the coming days. The court responds, All right, just to be clear, the intent of my order is not to prevent Figure Markets and GXD from in any way communicating with the proxy solicitor. What I was attempting to convey with my ruling is that it is the plaintiffs who should be calling the shots. It may be that the plaintiffs in Figure Markets and GXD are aligned on strategy. If they're not aligned, though, it should be the plaintiffs calling the shots. That is what I intended to convey in my ruling. So I hope that the clarification is helpful to the parties as they move forward negotiating an NDA. Attorney Lesner responds, Your Honor, can I ask one question about what you just said? If Figure Markets is going to be in communication with the proxy solicitor, that necessarily means they will have access to the names on the proxy list, to the names on the stock list, which I did not understand that to be Your Honor's ruling. I understood Your Honor's ruling is that they would not have involvement in the proxy contest, that it would be just the plaintiffs issuing directions. I think if Figure Markets and GXD are able to work with the proxy solicitor, it's the same as letting them have access to the stock list. The court replies, All right, let's do it this way. The parties need to meet and confer on the logistics for how this is going to work and the terms of the confidentiality order. If you can't come to an agreement, you can submit competing forms of order with letters explaining to me your position. It's too difficult for me, frankly, to discuss it in the abstract at this point, so I'm going to leave it to the parties to meet and confer in the first instance. Attorney Bayless responds, This is Tom Bayless. Thank you very much for the time. We understand that. We'll make it happen. And we'll be back to the court promptly if we can't agree to the form of NDA. Thank you very much. Attorney Lesner responds, Nothing further for me, Your Honor. Thank you. The court closes the hearing. Thank you all for your time. We are adjourned. The time of adjournment was 4:35 p.m.